Regulatory Sandboxes. My name is Jos van der Rijst. I'm at the location here in Eindhoven, the AI Innovation Center, and we will start now. We have some presenters who will be present here at the location here in Eindhoven, and some are remote and will join us from Oslo and Groningen. At the screen you will see the program for this afternoon. We have a mix of speakers from academia, from AI practice, and we have from regulatory authorities. So I think we have a nice mix of speakers to introduce you in this subject, and we hope that this will lead to discussion and to the next step in this subject. First of all, please mute your mic, and when you have questions, you can put them in the chat. Why this event? Well, the purpose of this event is the result of the AI Artificial Intelligence Act. It's a draft, it's a proposal, and in this act, the AI Regulatory Sandbox is introduced as an instrument, and this sounds very interesting especially from SME companies' point of view, and that's why we organize this event. There has to become a set of rules for these AI regulated sandboxes, and this is, in our opinion, the start of discussing what will be the regulatory framework for such a regulatory sandbox. After this event, we will continue working on this subject from different perspectives, and I will tell you a bit more about this later on in this after this event. Who organizes this event? There's two organizations. First of all, the Dutch Society for AI and Robots Law. The chairman will introduce this organization later on. And the other organization is the Dutch AI Coalition. Perhaps a bit more about the Dutch AI Coalition. As most of you know, the Dutch AI Coalition is a group of about 500 organizations who join the coalition and who want to support the idea of the application of AI in the Netherlands. And one of the subjects the coalition is looking at is the human-centric AI. And the part of the human-centric AI is the attention for the legal sides of AI, and that's my focus area in the Dutch AI Coalition. The Dutch AI Coalition has also supported the knowledge platform for information on legal and ethical aspects of AI, Legal Air. Please visit the platform. Then a bit about the location where we are here in Eindhoven, the AI Innovation Center. It's a center for incubator for startup and scale-ups in AI. A lot of companies are already here, and thanks for the organization for having us here at this location. Then I would like to give the floor to the chairman of the Dutch AI and Robot Law Organization.
Thank you for the introduction, Jos. Yes, I'm very grateful that our association can take part in this discussion. The organization or the association started in 2018, October 2018. And since that time, we have more than 100 members who are interested in artificial intelligence and robot law. We already discussed within our association the regulation. I don't mention it, don't name it act, because it is a draft regulation. And regulation is a specific legal instrument, so I want to make that clear. The subject of sandboxes is one of the subjects we also wanted to discuss in our association. And our association has different study groups, and we also look into the ethics of the use of artificial intelligence, the use of robots and artificial intelligence in e-health applications and other applications. So if you want to be a member, it's only in Dutch, that's the problem at the moment, but we will give some opportunity also to talk about subjects in English if you want to join. Where we want to talk about today, of course, is the use of sandboxes for AI applications. And the problem, I think, with these kind of sandboxes is that you must give ample opportunity to discuss certain subjects. If we look in the subjects that are mentioned in Article 53 until 55, we see that the subjects are prevention, investigation, and prosecution of criminal offenses, and also national security issues, public safety, and public health. And if you look in those subjects, there are already regulations, specific regulations. One of the specifics of this is that the GDPR is not applicable. So the discussions about the use of personal data that is given anyway in those articles to be used in the use of sandboxes, in the development of applications in sandboxes, will not be applicable. And the other subjects that are mentioned, they have their own regulations, and GDPR is not applicable either. And the other, in Article 55, there will be given the opportunity to get more SMEs active in the field to develop applications without too many regulations, and therefore we use the sandboxes. But those SMEs are hardly capable to be active in those subjects that are mentioned in Article 53. So I think that Article 53 and 54 and 55 are too vague, not specified. And you can, of course, expect it from sandboxes because you have to play in it. But still, I think that more specific indications of connecting with SMEs should be available within the AI regulation. And it's not at the moment, I think, that there are not enough opportunities to get SMEs really active in this field. But there are some observations. I can give you more observations, but I'll let it be like this, because we have a lot of speakers and they will have their considerations about the AI Act, AI regulation. And so I rather give the floor to the next speaker. Anyway, thank you for introducing our association. Jos is secretary of our association, and I'm the chair of this association. So if you want to join, think about things, you're welcome. Thank you.
Thank you, Rob. The next speaker, we thought about how to start this event. And we chose for starting the event with a presentation from the perspective of an AI data science company that develops AI applications. Gimmicks, a company located here at the AI Innovation Center Brainport. Martijn van Grieken, and he will elaborate on what an AI regulatory sandbox could mean for him in his daily work. Martijn, the floor is yours.
Thank you, Jos.
I have to figure out where I'm going to stand, but maybe this is a good place. I hope everybody can see me, hear me. Hello, everybody in the zaal. Let's see, gimmicks. What am I going to talk about? Developing trustworthy AI. That's our main goal, trustworthiness. It's very important in what we do, and I'll explain a little bit about that more. Ethical and lawful dilemmas. That is a little bit of the focus today. I'm still in the picture. Yeah. Cool. The agenda. Introduction of gimmicks, very short. Introduction of AI deep learning, very short, because I'm sure that everybody here and at home or in the office will understand what it is, but I'm going to touch on that anyway. And the AI Regulatory Sandbox, the developers.
Harder praten of deze kant?
Right, okay. So, gimmicks. We founded in 2014, going on 2015. We've got about 25 FTE, plus a flexible group of people working with us. We have data science expertise. I've listed it here: mathematical optimization, statistical analysis, machine learning, deep learning. And we operate a lot in the healthcare domain. And that is especially interesting today, because that is where we see some hindering of innovation. And we'll talk about that during this session. We are, like Jos said, we are here in the AI Innovation Center, and we also have our head office at the Kennedy Toren, which is next to the central station in Eindhoven. Important to know as well, we work according to the ISO standards. Because we are in the health domain, we have to adhere to the medical device registration and the Food and Drug Authority of the States. All right. So, just a little bit of a scene setting. Artificial intelligence, the intelligence with which machines independently solve problems. They imitate the human mind. This is the terminology that I'll use for the rest of the session. There are multiple terminology for AI, but this is the one that I'm going to use today. And importantly as well, almost all current applications fall under the so-called narrow AI. So performing one specific task very well, not a multitude of applications. So, artificial intelligence, is it new? No. Is it a buzzword? Yes, definitely. But since the 1950s, Alan Turing, obviously, we all know him. That's when AI started to grow in recognition. We had a few AI winters, but over time we reached a more specific AI. So going from artificial intelligence to a more narrow, which is machine learning, and even more narrow is the deep learning that I'll be talking a bit about today, especially the neural networks. So the neural networks, a quick one-on-one on deep learning, we imitate the human brain. So we try to learn. This is a neuron, and this is a bit more of a systematic view of the neuron. Information comes in via the dendrites, via the synapse, goes via the dendrites to the nucleus. It gets processed, information occurs from data, and it flows through the axon, through to the next synapse, etc., etc. So data turns into information through the neurons. That is basically the concept that we are talking about today. Unfortunately, this should have appeared on my next click, but it's in front of the mathematical presentation of a neural network. I try to, these are the neurons and the connection between the neurons. What I'm trying to tell you here is that rather than developers coding what the solution should be, we train a model. The computer trains itself by using a multitude of data. So this methodology is very data intensive, especially in the development phase. Once a model has been, an algorithm has been trained and a model has been developed, then it's no longer data intensive. So the training, that's important, that's key of my topic today. Training phase, the development phase, that is key. That is where a lot of data is needed. So sorry, well, anyway, it doesn't matter. It doesn't matter. So what are deep learning networks so great at dealing with? Data diversity, structured data, unstructured data. Structured data is like a table. So if we move a row with another row, the data is still the same. If we move columns, the data is still the same. But with unstructured data, if we change one pixel, for instance, in an image, the image is different. So it's unstructured. Obviously, in unstructured data, if we use methodology to make it into structured data, that's when we can deal with that data. But we start with unstructured and structured data. Okay, so deep learning is very capable of dealing with unstructured data. This is, yeah, okay, we're back. Few examples of where deep learning can add value to the medical profession, recognizing diseases or medical diagnostics. That's in images, video. Just 1 second. Yeah, there we go. Video, recognizing behavior, sound, recognizing emotion, text and speech, recognizing sentiment, and time series, recognizing abnormalities. I think the keyword here is recognizing. So finding patterns in unstructured data. This is where this methodology is very, very capable of. But it needs a lot of data. And that brings me to the topic of today, the AI Regulatory Sandbox. Again, the little yellow note should have been on a click, but that doesn't work anymore. It doesn't matter. What am I going to talk about? My agenda continued, because I started with another agenda. Agenda continued is about AI Regulatory Sandbox. I'm going to talk about the data science methodology, the process, which is the CRISPM. It's developed by IBM originally, but it's adapted to the data science. Then I'll talk to you a little bit about the risk from a legal point of view, and going in examples of hindered AI innovation due to the current regulations. From a developer's point of view, I'm not a lawyer, so please forgive me if I make silly comments. So CRISPM, the cross-industry standard process for data mining. That's how it started, and this is what it is. This is the schematic view of it. It's a highly iterative process with multiple phases, and it's the most used data science method. And we, at Gimmicks, we use this to deal with all our projects. Interesting bit, we start with the business understanding, so really phrasing the question that the business is after, this the medical profession or the industry, it doesn't matter. This is the business pattern. What are we after? What problem are we trying to solve? Then it's up to us to translate that into an analytical question. So business problem into an analytical problem, because then we can start looking at what methodologies are required to solve the problem. We need data understanding phase. The data needs to be prepared for the next phase, which is the modeling phase. After training the algorithm, developing the model, we can start looking into implementation of the model in the business to solve the problem continuously. And importantly, there's always monitoring. Have we done the right thing that still connects with the original business understanding that we started with? A very iterative, cyclic process, which is basically capable of dealing with all the projects in data science and AI that we deal with. But, and here, this is interesting too, because this should have been clickable, so we could walk through the model with all the questions that occur during the process. However, in each of the steps of the CRISPM methodology, we run into regulatory or ethical questions. And I've highlighted a few. For instance, which rules or regulations apply? It's very important in the business understanding phase. We need to understand the legal framework that we're operating in. Who owns the AI system? What are the risks? Also in the business understanding phase. If we move to the analytical approach, the translation of the business problem into the analytical problem, questions like, what is a fair AI model raise? Fair is from multiple perspectives. Is there bias or exclusion in the data? Very important. I'm going to talk about this a little bit more, because this is some of the hindering points with the current situation in developing innovations. Is there bias or exclusion in the data? Can I ensure data against theft? Very opportune at the moment, obviously, because on a daily basis, data is being stolen or hijacked. So can I ensure data against that? Is there bias or exclusion in the model? We had it in the data. Now, once we go into the modeling phase, we come into the same problems, but from a modeling side of view. Is there bias or exclusion in the model? Are there quality standards for AI models? Like we saw on the earlier sheet, it's been a historical field of expertise, the AI, because it's been there for a long time. But now, because it's been applied more, we run into the issues about standardization of AI. So from a legal point of view, ethical point of view, quality point of view, etc.
How do I deal with transparency in developing an AI model? Sometimes AI models can be very intransparent, but they could potentially solve the problem best. Do we want that, or do we want transparency? It's a trade-off. So we need to consider that as well. How do I validate an AI model? Very important in the evaluation phase. And who is responsible for the AI system once it is in business, once it is implemented? All right, so all kind of questions that AI developers deal with on a regular basis. The beauty, however, is that there are solutions to answering the questions. For example, Jos introduced Legal Air platform, which is collating a lot of questions from ethical and legal perspective, privacy, security perspective, to answer developers such as ourselves with these questions. We can also go to a law firm and try to get the answers that we need, or ethical specialists. So if there is such a platform, if there are lawyers and ethical specialists, why are we here? What can we do? What more can we do? What is currently out of our reach? I'll try to phrase that, given a few field examples where opportunity for innovation was in some way hindered or slowed down. Interesting. No clickable slides, which is unfortunate. However, let's continue. Monitoring fetal health. This project, we were asked to objectify subjective gynecology's expertise, and I'll try to explain that. This is the choco signal, and this is of an unborn child, so the heartbeat, and the contraction signal of the lady in labor. Gynecologists look at these signals and say, hey, I recognize a pattern based on my experience, based on my training, and that pattern suggests that there might be stress with the unborn child, and they intervene. If we want to automate this process to support gynecologists, for instance, if they are just out of training, for instance, and they have less experience, can we use the information, the experience of the trained professional to support the younger gynecologists, or the gynecologists that just started? That was the idea of this project. But like I mentioned, we need a lot of data to get the mathematics out of these patterns. So what happened? We had low quality data set, and there were two options in which we could still try to get this innovation forward. We could increase the amount of data, both from a quality and quantity point of view, or use different algorithms to recognize the desired patterns. Because the second option is suboptimal, the results will be less good to recognize these patterns. We really wanted to get more data. And here we ran into a problem. Because we are in our company and our health domain, we are dealing with a lot of personal information. GDPR, AVGs for us is a bit of a bottleneck. It's good it is there. We highly appreciate personal information, but sometimes it would be great if we could just think, how can we work together to make innovation happen nevertheless. So here, by only selecting the patient, let's go this one first. There was a lot of data. So data was not a problem. There was high quality available data, but because there was no consent from the patient to give this data, there was no workable way of getting consent from the patients, even though the data could reach us anonymized, so no personal information, only the information on the heartbeat and the womb contraction and the end result that we needed to train towards, whether there was stress or not at the unborn child. Still, there was no way we could get that data. So that was very unfortunate. It was anonymized. I'll do this because obviously the hospitals could, in a way, relate it back to a patient. That's why there was no way we could move forward with this innovation, which is unfortunate. So we went to the first option, to use a suboptimal mathematical method, and in the meantime, continue to get data with consent to improve the model over time. But it slowed our innovation down. So it would have been nice if there was a way to deal with anonymized data in a proper way that would stimulate this innovation. Endoscopy, another project that we started with a hospital. We thought about it, we conceptualized about it. We had our toolbox of methods ready to deal with the data that was available. However, what was interesting, what we found out in the early stages of this project, and that's why the project was canned, we couldn't move forward, was that sometimes in these images of the throat, if the camera was turned on too quickly, there was a face. So there was a person in the image material. And because we discovered that, during the DPIA phase, the data protection impact assessment, we could not mitigate the risk because we could never guarantee that there wouldn't be a face in the data. So we could not say during the DPIA, there's no personal information in this data set, so we can move forward to with this innovation to detect throat cancer. So this is unfortunate. And it remains a difficult topic in DPIA. And this is not the only case. I apologize, that's hard for me, but suicidal behavior, that's what it says there. This is a train station. We were approached to think how we can use technology, cameras, to identify suicidal behavior. So we talked to psychologists, we talked to the client, and we found a way, technology-wise as well, we found a way how we can translate certain patterns, behavioral patterns, into recognizable mathematics. Conceptually, because there was no data that we could use to train. Although in the end result, and this is interesting, we wanted to go to stick figures with edge devices. So the intelligence would live on a camera, and there would be no personal information because we would use stick figures. But if these stick figures move in a certain way, you can identify the pattern that may suggest suicidal behavior. But we cannot reach that stage because we need data in which there is personal information. And we cannot get the consent of all the people that are walking around on the train station at the time of a potential suicidal case. So again, this is something it would be nice to think about. How can we move forward with innovation that is very beneficial to society in a proper way? So dealing with personal information, respecting people's privacy, but still trying to get this important technology out there to support cases or recognize cases of suicidal behavior. Last but not least, I think it's really funny, this one. This is a camera trap. So we were asked by one of the universities in the Netherlands, can we automate the process of recognizing wildlife? The camera has a sensor, and as soon as an animal walks past, then it takes a picture, 15 pictures to be precise, because that would also give identification of the trajectory of the animal. So in which direction is it walking, or what is it doing while it's walking? Very interesting. Now there are ecologists that hours and hours and hours look at these images and make notes. This is a deer, this is a boar, etc. Which is yeah, it's competitive work. It's slightly intelligent, so it could be automated. What was the problem? Again, we could not guarantee during a DPIA that there was no personal information, because if the hunter or any person walking in the woods walks across the camera trap, he or she gets on camera as well, and that makes it pretty hard to say, hey, there's no personal information in our data set, in our training data set, because we need a lot of information to train on. And there was actually a case where, this is of course not the actual case, but there was a politician in the country that was walking in the forest with not his wife, but his girlfriend, and he was on the camera. So that was very sensitive, public opinion raised, etc., etc. So it's important that we deal with these situations. How can we still move forward with the innovation, supporting ecologists to learn about wildlife behavior, but also respecting privacy? Is there a way that we can guarantee privacy in an experimental setting that can use us to move forward? So again, an interesting case. Well, I'm going to stop. Mitigating the risks is the problem that we encounter because there are the regulatory settings that we deal with now. It is for us very difficult to mitigate the risks. And that concludes for us that we either not do the innovation or it becomes a much larger project where we slowly, step by step, try to mitigate the risks. But it's always difficult because it is so data rich. But importantly, the development phase, not the exploitation phase. Like I said with the stick figures, once we have the behavior, once we have the algorithm that can analyze these patterns using stick figures on edge devices, which do not even send out any information, then we are in the safe zone from a personal information point of view. But how do we get there? That is a question that we try to deal with on a daily basis. And hopefully the discussions we're having today and in the near future will help innovation move forward in a respectful way. Okay, so what do we need? The AI regulator. Why do we need it? By creating more possibilities in the analysis and development phase, as I mentioned before, profiling, discrimination, and exclusion during exploitation can be prevented. And I'll highlight that a little bit further. If we use a data set to train an algorithm to become a model that we use in implementation phase, but we have low quality, but mainly low quantity data that is potentially lacking representation for the actual target group that this model will work on, let that sink in. There's potentially not a fully representable data set that aligns with the potential target group of the model, then we are potentially in trouble because there might also be bias in the training set because the training set is limited. So we need to think about how can we make sure there's no bias in the training set, there is no lack of representation in the data set, the training set. So once we implement the model, it is fully in respect of the hypothetical situation. So we train with large data set with no bias, which is representable. Then only then can we feel confident that the model will not discriminate or have bias. If the sandbox could help in that regard, in one way or another, and this is multidisciplinary area, we are only developers, we're not lawyers, we're not ethical specialists, but if we work together, we're not policymakers, but if we work together, then it might be very interesting to deal with these topics. Limiting possibilities in the development phase actually encourages negative profiling, discrimination, and exclusion. We've seen a lot of examples in the media that models are negatively discriminating or they cause profiling. It is one, because stakeholders are not informed, that's one, but it's also often that the data that was trained on was not representative and it was bias in the data. Discrimination moves forward in the model. All right, because the AI Regulatory Sandbox offers more room for testing with representative data, here we go again, the applications can be validated much more extensively and risks can be prevented. So if we work together on how can we deal with training models in a proper way, in a sandbox way, which is highly monitored and safeguarded, then we can move forward with the validation and prevention of risks. Finally, the AI Regulatory Sandbox drives more innovation in the Netherlands and the EU. Due to strict laws and regulations, the EU is in danger of falling behind in the field of AI. As a result, innovative companies and the best students may go abroad. I say may, because we do see it happen. Other countries are dealing with privacy on a different way, and I'm not suggesting that's better, absolutely not. But we need to deal with our situation in a way that innovation can still be stimulated and that students and companies stay here and work on good innovations here. And the EU may miss commercial opportunities and may also become increasingly dependent on foreign countries in this regard, which is a shame, of course. And that was it for me.
There are two questions
Yep.
from the audience,
Yep.
or at least online. First of all, we have a question from Ashley Moons. She wonders, how does Gimmicks collect the data they use to train the AI?
It's always with the client. So the client has the business problem. The client has the data set, and we discuss with the client what is the required outcome when we translate the business problem, which could also be a medical problem. Medical diagnostics, I phrase it as a business problem, could be a medical problem. When phrasing the problem and translating it in the analytical approach and thinking about data collection, that's when we as developers, together with our clients, talk about which data is needed. And one part of that is the data set that we are using, is it representable for the target audience of the model in the end? So we don't collect it ourselves, we collect it, or our clients collect it, or they have it, or we suggest a way of how the client can collect this data. So it depends. It depends on the question and on the client.
Yeah.
But we at least we advise on what kind of data is needed and how much data is needed.
Great. She says thank you. Then Evert Stamhuis, he has several questions actually. First of all, in relation to the fetal stress example, did you do discovery in working with the 89 and 36 articles, I think, of the GDPR? But
I think so too.
I can imagine that you might not be able to answer this by heart. So maybe you can type this towards Evert Stamhuis if you
it's a good idea.
have some more info.
Let's make a connection and I'll pick that up for you.
This is actually interesting though. In relation to the endoscopy example, was data cleaning with AI considered?
It was considered. It was very timely, and yeah, I know what you mean. I mean, you can always have an AI model recognize people first, and then delete the data set from the human interfaces. That we didn't consider that at that point, but it is something that we are discussing at the moment, so we can move forward. So data cleaning, pre-processing is an important step in dealing with that kind of uncertainty. Yeah.
But isn't it also at the same time a bit of a paradoxical question, because you are still processing the data?
Exactly. So because that data goes into the machine as well, and if a DPI looks at that, then you can still not guarantee that there's no personal information. So it's a bit of a paradox, a bit of a, how do you call it, the Droste effect.
With the tin can.
Yeah,
exactly. And then the last one in relation to the suicide case, how to correlate to risk of suicide when you only have risk of depression as data available, I suppose. But
I'm not sure what the question means. If I assume the question means that we wouldn't have data of actual events, that is not the case, because there is data available on actual
suicide risk.
Suicide. Yeah, that's from train stations and bridges. There is information and material there. Yeah.
Okay, I think that we'll give Evert the answers that he seeks for now.
Yeah.
Thank you.
Cool. You're welcome.
I have a question too.
Yes.
Why don't you use artificial data? If you think it can be based on the actual data, further develop it as artificial data, then you can train the system.
Yeah, but it is supposed that artificial or synthetic data has the same statistical values. So in a structured data set, it's probably doable to get the statistical information out of the data set and then synthesize that. Yeah. So yes, I totally agree. In the case of unstructured data, imaging, videos, I haven't come across synthetic data that is capable of doing so. We are talking to suppliers of synthetic data, but it's more in the structured domain, not so much in medical diagnostics, for instance.
Yeah. The other thing is that in the sandboxes give you the exception to use personal data. So that would be not the biggest problem, because you can use personal data, and it's based on law, one of the exceptions of the GDPR as well.
Mm-hmm.
So you would have the opportunity, if you're not capable to use anonymized data, to use personal data. Of course, that has to be more regulated, yeah. But the opportunity is given in the artists considering the sandboxes. So
that's fantastic.
Yeah, so you have to consider it.
Yeah, no, that's fantastic. So I'd love to hear more about that, especially once it becomes more regulated. It's doable. Then yeah, that would be fantastic. So great that it's already
it's an
an opportunity.
Given
Yeah.
in the articles considering the sandboxes,
Yeah.
because that's where the sandboxes are for.
Yeah, that's perfect, and that's what we were looking for, and so I'm happy that this discussion is now here and that this information is available for developers as well. So yeah, thanks.
Sorry, thanks, Martijn, for your presentation. I think this this sets the scene. This is the perspective of a data science company that develops AI systems. Now we go to the next speaker. We are a bit ahead of scheme, but that's no problem, I think. The next speaker is Sophia, professor at University in Groningen. Actually, her paper was one of the first papers we discovered about this issue, and it is also mentioned in a lot of other later papers. But she started, in my perspective, she started discussing about the idea of the AI Regulatory Sandbox. So I'm very welcome. Thank you for Sophia for giving a presentation here. I think you can. You are in Groningen, and I think we can get you at the screen now. Yes, welcome. And I think you can move the slide so I get the screen to you.
It's not an option to speak at the same time.
Okay. The screen is yours.
Thank you so much, Jos. Can you hear me well in the room? Well, I hope so. So the room has been muted, so I will assume that you can hear me well. If you hear me as well at home, I would appreciate some feedback from the chat, so that I'm not like speaking to an audience that cannot hear me. So thank you very much for the invitation. I'm going to talk about regulatory sandboxes from a bit of a more theoretical perspective, and I have been working on experimental governance already for many years. I started actually in 2010, back when it was not popular at all, talk about experiments and innovation. But I already did my PhD exactly on this topic, on how we actually can design instruments that allow us to, on the one hand, safeguard risks, but on the other hand, to also promote innovation. And now with the AI Act proposal, we see that finally there is perception that we actually should have instruments that balance innovation and regulation, and that it is actually possible. So I'm going to discuss this this difficult balance between regulation and innovation in the context of regulatory sandboxes. I am a lawyer, so in that sense, I will definitely pick up on some points that were discussed just in the previous presentation. And I'm also going to pick up on something that is not very often discussed, but is actually quite important, and it pertains to the possible challenges from a legal and methodological perspective of implementing regulatory sandboxes. Because so far we have some experience with experimental governance and also with regulatory sandboxes in the fintech, for example, but there are also quite a lot of limitations. So as we move forward with this idea of expanding the sandboxing approach, it will be important to also take into account the knowledge we have already acquired from other areas of experimental governance and regulation, and make sure that we address methodological challenges. I'm happy to discuss, of course, afterwards. So when regulating innovation, and actually when just discussing innovation in general from a regulatory perspective, we know that regulators face usually 4 big questions. The first one is very well known, it's whether to intervene or not. So from a perspective of traditional economics, there is, of course, this idea that you should only intervene if the market doesn't work. So the laissez-faire approach, which we know very well, and which, in some cases is still advocated by many. However, in most cases, especially in the context of AI, we have long moved past this stage. So the question whether or not to intervene is not even a question that is really posed in the context of AI. So we basically move immediately to the 3 other questions, which are exactly very important: the how, with whom, and when. So how to regulate is something that has also been discussed thoroughly in different areas of technology. And this question actually asks for the balance between public and private interests. Also in AI, this is something that we have to work with, because on the one hand, we have, of course, the acknowledgement that AI can be immensely important for the promotion of public interests, but at the same time, not always will we have private interests that are aligned with the potential that AI has. And we, of course, we also know that AI has, the design of AI can contain many biases, which are difficult to eliminate or just costly in general. So, of course, this balance of public and private interests is part of the regulatory discourse, and this is something that does put a lot of pressure on regulators to get it right. Also here, the how question is something that brings us to the idea of regulatory sandboxes. If we are to actually design an instrument that is indeed innovation friendly, we might actually here want to find out whether the how question can be answered with an experimental approach. And I'll get back to the definition of a regulatory sandbox in a minute, and because it's not always experimental when we sandbox. The third question, which is also very important for sandboxing, is with whom are we going to regulate? So regulators do not only regulate just top-down nowadays. It's very well known. But the question is, who are the partners in this regulatory process? With sandboxing, it's quite clear that we need to have private partners. Sandboxing is not something that is just done top-down. The decision to sandbox it is probably, but not the operation, the design, and implementation of sandboxing. So the third question that regulators want to ask themselves is, with whom are they going to regulate? Is it going to be a co-regulatory process? Are they going to actually delegate much of the regulation to private companies, for example, with systems of self-regulation? This is very often something that happens with context of standards. Or are they going to accompany and supervise the regulatory process? With the regulatory sandboxes, it is important that this question, the third question, is answered in a way that public and private regulators, public and private parties are basically involved in the regulatory process. And this is something that we actually now acknowledge as being very important in the regulatory process, especially when it comes to technology about which we do not know enough, or about which we actually need to have the cooperation of private parties. The final question that I have identified for defining innovation-friendly regulation has to do with timing, and this is one of the issues that I have been working on for many years as well. When do we regulate, and how do we actually make sure that this regulation has the perfect timing? So the timing of law and regulations is important because there is, of course, this old narrative that law always lags behind technology. Law is always a few steps behind. This narrative is a bit contested by lawyers. So nowadays, we don't always accept it because it's not always empirically proven that law lags that much behind, because law is actually quite elastic. So for those in the audience who are not lawyers but have this perspective that law is always, setting, boundaries to technology, I think sometimes it's always a question of interpretation, because law is not as burdening as it may seem in some cases. It's very much the question of interpretation. But of course, when it comes to AI systems, there is, of course, sometimes a need to actually really make sure that we don't only have the elasticity of concepts, but it is important to actually come up with new, with new concepts. So the timing question is important because if indeed law does not offer a timely regulation, this can have negative implications for technology. But at the same time, this is a question that we should ask very sharply and also with empirical evidence, because, as I said, the narrative of law always lagging behind is also a narrative that has been very often used without sufficient evidence. The regulators, they often muddle through in the process of finding the best instrument to regulate innovation. And this is something that has been broadly studied outside the law. So outside the law, we have seen quite a lot of studies on innovation, on digital innovation, digital transformations in law. It's fairly recent. So this is just some references for those of you who are academics or are interested in learning more about innovation and law. There are more recent studies that try to actually show that there can be a balance between regulation and innovation. but this is actually still fairly recent, I would say. What we see now when it comes to innovation-friendly regulation is that in the last years at the European level, there has been an attempt to actually address these issues and to try to bring these 4 questions more to the center of attention. So this one of the key ideas that has been put forward is that we actually need to introduce the idea of innovation and the innovation principle as one of the parameters of regulation. So we now have the innovation principle, which is still not regarded as a legal principle of European law, but it has been inserted as a principle or as a standard of better regulation. So this is something that, though contested still, because it was something that came from the side of companies, from the biotech sector, it's something that has definitely changed a bit the attention. So it's now besides the idea of managing risks with regulation, there is also this idea that has been added that regulation should also take into account its impact on innovation. So regulatory burdens have to be measured. There should be actually special attention just to the impact of new rules on economic growth and development. Then this we have seen consistently in the last years, especially during the German presidency of the EU. So what we see is that a number of the instruments have been proposed, and not surprisingly, the AI regulation, the AI Act, is one of them. So in the AI Act, we see for the second time, actually the reference to innovation-friendly instruments, and regulatory sandboxes are indeed one of them. So the AI Act actually presents regulatory sandbox and other innovation-friendly measures, as it's, I'm quoting from the Act, as something important that actually can balance between the more restrictive approaches that are adopted for high-risk AI and the possibility to actually insert some exemptions, or at least to actually work together with startups to develop new AI systems. So basically, the idea that has been put forward in the last years is that it is possible to actually bring together regulation and innovation. There's this awareness, and flexibility and experimentation have been regarded as a bit of the promise to actually bring this two concepts of regulation and innovation together, even though they have been seen as opposites for many years. So the experimental method that underlies sandboxes, in some cases, not all of them, basically is something that has been actually present in regulation for some years. In the Netherlands, we can trace back experimental regulations back to the 60s in the field of education. And nowadays, we actually have experimental clauses in numerous fields, ranging from education to traffic regulation to energy. So this is something that has definitely expanded in the last years. So it has become more common. It has also become more common because there is this idea that if you want to produce better regulation, if you want to make sure that regulation is more cost effective and more impactful, we need to make sure that we also collaborate more with with private parties, that we actually experiment, gather evidence, and try to define regulations that are evidence-based in a way. So it's here with this in the setting of better regulation trends, that is experimental, collaborative, and sandboxes emerge in a way, because we see that, especially at European level, there is the idea that if we actually experiment with regulation, we can not only promote innovation more, but we can also make sure that that we promote higher quality of regulation. This is something that has also been present in the Netherlands, so it's not something that has only been proposed by Brussels. We see actually these better regulation trends in multiple countries of member states. The Netherlands tends to be one of the most advanced ones in terms of thinking and literature in better regulation. That's why I'm mentioning that as well. So what we actually see is that the idea of sandboxes has really entered the idea of regulating for innovation. And the best examples, the first examples, of course, did not come in the context of AI. They actually come from fintech. So since 2015, the number of sandboxes has really mushroomed. And we see them especially now in the UK, but also in France, in Italy, a little bit everywhere, actually. I think that in most Commonwealth Commonwealth countries, there are multiple fintech sandboxes. And basically, the idea of sandboxes is to actually create a safe test bed for innovation. That is just very basically the key idea. The idea of regulatory sandbox is actually something that is very often narrowed only to experimental approaches, but actually in reality it's a little bit more than that, because a regulatory sandbox can offer different ways of approaching innovation. So it is a safe test bed in the sense that you actually have a cohort with which you experiment, but you don't necessarily need to experiment in the sense of introducing an experimental clause. You can also just design a regulatory sandbox with different degrees of experimentation or of flexibility. So you can, for example, design a sandbox to provide regulatory relief or regulatory customization to a certain cohort. So in that sense, the regulatory sandbox is not just necessarily something, an instrument of experimentation, but it can be an instrument of compliance, of guidance and collaboration. So if we start with what it is from a legal perspective, because I think that's quite important, and I'm the lawyer, of course, here. When designing a regulatory sandbox that introduces an experiment, so a derogation in a way from existing systems, I think it's important to say that experimental regulations and sandboxes here will resemble each other a little bit more. And what we have in terms of like experimental regulation and governance is basically two models. The first model is the model of derogation, where basically what we do is we say, well, there are all these rules that are applicable in general, but in this context, these rules will not be applicable. You'll be exempt from complying with these rules for some period to see whether these rules are needed or not. So this is the derogation model that we have in the Netherlands, for example, and that actually sometimes occurs and is used as well in the regulatory sandbox. So if you are one of the companies that has been selected for a regulatory sandbox, you sometimes don't have to comply with all the rules. There will be an exceptional system that will be applied. The devolution system, I will not delve too much into that, but that's a different system of experimentation that is more common in the context of federalism and also centralization, where basically centralized units or states can actually have a totally different system. This is actually a very specific idea, so I'm not going to delve into it. And I don't think in the context of regulatory sandboxes will actually be the case, because this is specific, but this is something that very often is regarded as something that exists and that has been actually part of the history of regulatory sandboxes. So when we actually think of the idea of regulatory sandboxes, what I think it is important to take into account is that the idea of having a sandbox very much has to do with actually this concept of making sure that we actually test something safely in an environment that is uncontaminated in a way. Of course, from a legal perspective, this is almost impossible, but we do have the possibility to actually have this new paradigm where you basically have some level of experimentation and flexibility. One myth that I would like to debunk a bit that I see very often is that regulatory sandboxes are always about experimentation and always about derogating from rules, setting them aside. As I've said before, this is not always the case. So sometimes we do have a regulatory sandbox that very much resembles an experimental regulation, but sometimes we don't. We sometimes only have systems in which startups that are part of the cohorts are accompanied, and they in their guidance, in their compliance with a certain regulation. Or in some other cases, just basic customization of the compliance. So in that sense, the regulator can, of course, define a different kind of sandbox for different groups. And this is important because depending on the level of the sandbox, on measures offered by the sandbox, of course, our approach as lawyers will always be different. There's a very big difference between saying we're going to exempt cohort from compliance with rules, or just saying we're going to guide them in the compliance with certain rules. And I think these different levels of implementation are quite important to consider. So we know that the current AI regulation proposal, the AI Act, has included these measures in the context of measures to support innovation. So as such, basically what we see is that the AI regulatory sandboxes have been included in Title V. And the idea basically here is to actually use them as a way of improving supervision and guidance, but not derogate. So that's why I was emphasizing the need to actually distinguish between the regulatory sandbox that exempts and fully experiments, and the regulatory sandbox that only offers guidance and compliance and customization. We are still talking about a proposal, so we actually don't know exactly how this will take place. But what we do know is that it is important to actually know a bit about how they work and what the limitations of regulatory sandboxes can be. So one limitation that I'd like to discuss with you today, the final part of my talk, has to do with the methodological limitations that experiments can have, and regulatory sandboxes, even if they only offer small compliance changes, they are in a way can also be guilty of the same problem. So one of the main problems that has been identified with experimental governance, and which can also be possibly a future problem of sandboxes, is the methodology. So this was identified, for example, in 2019 by the French Council of States. In France, there are a lot of experimental regulations already for many years, not necessarily in the field of technology, but in many fields. And one of the things that has been identified is that very often experimental regulations are implemented without really a proper methodology. So one of the things that I have argued in my scholarship is that when we actually do not comply with the methods of conducting a proper experiment, proper sandbox in a way, then the question may arise whether we are actually exempting people, exempting startups, and exempting a cohort in a way that's also legal. Because the idea of a sandbox or an experiment in general is to actually gather evidence to actually produce better regulation, to regulate innovation in a better way. So if the regulatory sandbox is designed in a way that is actually not methodologically responsible, then it might actually be giving someone an advantage that's not really proportionate, for example, or it might be disrespecting equal treatments. So the idea basically here is that it is very important, it will be very important for the future ahead of us when designing regulatory sandboxes to take into account design and methodological issues regarding the internal and external validity of experiments, but also making sure that we design regulatory sandboxes that are not just sandboxes that are important for a couple of for a very limited number of startups, but then can never have limited generalization. And that is something that has been actually one of the main critiques of sandboxes. You basically invest quite a lot in the design of a sandbox, but basically the fact that something works out for one startup or two startups does not mean that it will work out for the general population or for the general world of technology. So this is something that I think it is important to take into account. This is something that I think, in a way, has been a little bit lost in this discussion on sandboxes and in general on discussion around the regulation of AI, because very often people are most people do not really understand how the regulatory sandbox can help. They can help because they offer an option for flexible regulation. But in the long run, I think they will only offer a viable option for flexible regulation if they are designed properly, if they are designed with the idea that they can really contribute not only for 2 or 3 companies, or actually usually it's more, but like 10 companies that are in the cohort, but they actually can make contribution in general for AI as such, or for a specific field like medicine, as it was discussed in previous presentation. So I can, of course, in the Q&A delve into some of these methodological issues and legal issues. But this is something that I just want to give you a hint about, because the methodological issues of sandboxes and experiments in general are something that I would say are definitely the weak points of sandboxing. To finish, I would say that I think as lawyers, we definitely need to, and as educators, in my case, I would say that we definitely need to make sure that we actually see a paradigm, that we are prepared for paradigm shift from our traditional reactive regulation or responsive regulation, which is a little bit ahead, to an idea of anticipatory regulation. So basically already thinking ahead in terms of what can be future-proof, how actually these systems, AI systems are developing, and how we actually can contribute to them. This can mean, of course, in a way that we design more future-proof regulation, that we experiment more, that we actually think more about the outcomes rather than about all this, the details that regulation usually have. But also, I would say that when thinking of anticipatory regulation, I think it's important to think of also these methodological concerns that very often accompany experiments. So not just design regulatory sandboxes because it's a buzzword, but actually design it because we want to learn something. There is a bigger question in terms of learning that we want to actually investigate. And it's a question that actually can potentially be helpful for the regulation of AI as such, or as a specific field. So to conclude, I would say that I think regulatory sandboxes do bring about quite a lot. They do have very often this idea of experimental approach to innovation. They can help us introduce more flexibility in the regulatory system. And I think this is very important. But I think it is also important to think about all the methodological issues that can also bring about the problem that if uncoordinated, we may have some kind of like regulatory sandbox shopping between different member states, which of course should be avoided. And I understand from the proposal that there will be some kind of coordination at European level. But actually, I think this is exactly important that we make sure that when talking about sandboxes, that we actually can understand how they are designed, how they are coordinated when implementing European legislation, and whether or not they actually indeed give rise to better quality regulation that is indeed regulation that aims to learn from practice, from private parties, while managing risks at the same time. Thank you very much.
Sophia, thank you very much. Can you maybe direct your attention for a moment also to the chat? There were some questions.
I see there are some questions.
The attendees, and maybe also questions from people in the room. Then best probably to handle that one first. So if you can ask your question, maybe I need to relay it, but
do it now?
Yeah, just do it now. Maybe you come a bit closer so she can actually hear you.
Let's see.
And then we need to switch back to her for the answers, and then she can direct also to the questions in the chat. Thanks.
Hello. Thank you for your nice talk. I'm an alumnus of the Groningen University, but at the total different end of the spectrum. I was trained as an astronomer, so totally have no legal expertise. But I have a long time worked in data analysis. And my question is, when you allow a company, or me for instance, to enter a sandbox to do some research, development, whatever I would like to do, for a certain period of time, what happens when this period terminates? I have developed something, I have used data, but when this period terminates, for future research, I need these original data. Otherwise, there is no continuity in the software development. So how do you envisage the termination of a sandbox period and the continuation of the development of software or a product? Thank you.
Thank you. That's a very good question. So that is usually, I mean, of course, we have a regulator who will speak afterwards. So I don't know how this is regulated by the data stillnet, but studentnet. But I do know I've actually looked into termination conditions in other countries, and I mean, the regulator defines this in contracts from what I've seen with the startups, with the cohorts. So the termination conditions very much depend on what's agreed. So in fintech, this is something that is agreed with the startups. So, and this is usually something that is announced in the call for participation. So as a company, what I would advise you is to make sure that the conditions are favorable for the company afterwards, because of course, you don't know whether data will be made available as open data. That could be the case sometimes, and that can be good or bad for your company. So I don't have like all-encompassing answer, but because this is always regulated in a private contract, privately between the regulator and the company. So in regard with, of course, GDPR regulations and everything. But this is something that is, basically defined by the regulator in the call. So this is something that you have to always check each case, I would say. I'm sorry, I don't have a better answer, but this is what I have seen from analyzing quite a lot of regulatory sandboxes throughout Europe. So are there any questions from the public? Because I have a lot of questions from the chat, I can see.
No, you can go to the chat right now, Sophia. Thank you.
Okay, thank you. So Irvet asks, do you think the amendment that the council suggested regarding testing the real-world conditions? So I'm actually not sure what this amendment is. Maybe I didn't follow it. So if you could send me an email about it, I can probably answer, because right now I don't have it very present. So I'm not really sure what the amendment is that you mean. So, but I'd be happy to engage in discussion if right now I'm not really I don't have it very present. So I'm sorry, I can't answer directly. Arno, big companies used to use small related companies not to care about the law and experiments like Sandbox, but now with government guarantee. Do you know if they still do, or they prefer to do this in a governmental sandbox? So that's a good question, Arno. So basically what I know is that I don't think the idea of regulatory sandboxes is to actually support big tech. But what I do know is that big tech has been trying to actually support small tech in this, because small tech can participate in regulatory sandboxes. So I do think because it's known that big tech tries to actually use experiments to move away from the regulations, I think what will happen is that what I already see is that a lot of big tech companies are trying to invest in small startups and support them to, of course, later buy them with better regulatory conditions. So I do think that there is already this movement, non-legal movement about it. Also, I think what it must be said is that I think when designing regulatory sandbox, it is important that we cannot avoid that a startup will be bought afterwards by big tech. I don't think we can avoid that, but I think we can have to make sure is that we are truly supporting innovation that could not be done otherwise. Innovation that really has to do with it will struggle with regulatory limitations otherwise. I think that's something very important that we also saw, for example, in the context of of fintech, and that worked very well there. So I think that is something that we could probably support more. But again, I think it really depends on how we frame the regulatory sandboxes to make sure that they actually the targets that are profiting from it will be small tech rather than big tech, because big tech will always profit from it indirectly, but that's something that is very difficult to actually address. So Bart Schermer has a very good question. He asks whether the regulatory sandbox is indeed presented as a silver bullet to solve all issues related to innovation, and whether regulatory sandboxes can actually meet these goals. This is a good question, because I also, when I first saw the regulatory sandboxes, I also thought, well, this is a bit like a promise that cannot be kept, really. I don't think regulatory sandboxes can actually help as much as it seems when you read the preamble of legislation here, because regulatory sandboxes are only presented as an instrument with a very limited application in a way. So it's only for compliance, supervision. So it's quite limited in its scope. It's not for true experiments. So I don't think there will be really like the car that will promote innovation like wildly. I do think that more work has to be done on the side of the European Commission to really continue contributing to innovation-friendly measures. But I think it just at least sets a bit of a precedent in considering the role of innovation-friendly measures. So it at least opens up the room a little bit more. But in terms, it will not be innovation-friendly measures that will actually, open up, the world of innovation to Europe in a way, because you actually can. There's just so much, so there's a limited number of companies can participate in each sandbox. So in a way, it is still quite limited. It's not like innovation for all. It's quite limited in a way. same way the Horizon projects are. So I think it will help a bit, but it's I don't think it will deliver the promise that actually we see being kept. So Abert also has a question for me. How would you evaluate a situation where compliance with law pushes moving away from appropriate research standards? So I think this is something to be avoided in a way. I think it's very important to make sure that we don't use experiments to actually move away from important standards like consent requirements. And this is something that actually I defended in my PhD thesis already many years ago, obviously, with experimental regulations. We cannot use an experiment. We cannot use a regulatory sandbox to obtain to fully obtain something that we shouldn't obtain with a regular law. So this is something that has to be said. So the idea of an experiment is to actually do away with requirements that are just burdening companies, that are not really having anything like deadlines or like burdens of proof that are just very detailed. So it should be about procedural things. But when it comes to consent requirements can be, of course, very detailed and very onerous, but it touches upon something that is important as well. So in that sense, we shouldn't use experiments to actually achieve things that would normally be considered essential so we cannot do away from essential elements. And I think this is something that in the next presentation I probably will be discussed, because I think it is important that regulatory sandboxes are not a way to obtain a deviation that is proportionate from regulations. So this is something that I think is quite important to take into account. I think I answered all the questions. But I mean, as I said, I've been working on this mostly from a theoretical perspective, and I have been analyzing all the reports that have been done from on regulatory sandbox from different agencies. But of course, when it comes to GDPR, when it comes to the design of privacy-friendly regulatory sandboxes, I think Mr. Goldbrandsen can actually definitely probably delve into this, because the Datastuurnet has been really doing this in practice. So I think they're probably the best regulator to actually address this issue much more than an academic who studies this from a theoretical perspective.
Yes, one.
Sophia, we have one more question from the audience.
One last question.
Of course, go ahead.
Don't you think it's also a sandbox or playground for the European Commission and regulators to see what's possible and to specify the rather vague articles of the AI regulation itself?
I think it could be. Honestly, when I first saw the Title V, I would think that they actually should even use it a little bit better, because right now it's very limited in application. But it could be actually a sandbox for new regulations in a way. So I could, if it would be defined a little bit in other terms, in terms of slightly broader terms, I think the regulatory sandbox could be an instrument for the European Commission to actually make the AI Act more future-proof and to allow for a little bit more, more room to actually regulate for the future, and also to regulate AI systems that are not really there. Of course, that is the idea of Title V, but right now it's very limited. Also, this will change probably because it's still a proposal, but I think it really needs to change in the sense that we need to make sure that it really favors, small, medium enterprise, of course, innovation that is really necessary for Europe, that doesn't allow for deviation from European values and fundamental rights. I think that's very, very important. And that all regulatory sandboxes are also defined in a way that is methodologically responsible, that we actually know exactly for which period they will be set up and what we can learn from them and with what actors, something that we have already learned quite a lot from the field of experimental regulations. And very often this is something that is actually laid down in statutes. This is not just relegated to regulations. This is something that is present in experimental clauses. So I do think we do need more information, and I do regret that they didn't use it for other fields, or it's in a broader way. But I do hope that in the final draft this will be taken into account, and we will know more about its implementation, and also more about how we can actually use it indeed to make sure that the European Commission also makes, turns this act into like a future-proof piece of legislation.
Thank you, Sophia, for this presentation. My conclusion is that there is a lot of work to do for setting up an AI regulatory sandbox. The presumption, perhaps at the beginning, is oh, that can't be that difficult. We copy the framework from fintech or another sector, and that's it, and then we can start. But I learned from your presentation that there is a lot more to do before we can start with a regulatory sandbox for AI. So thank you for your presentation. Thank you for answering the questions. There was one question about the amendment from the European Council. I will send it to all the participants to this event, as well as the slides of the presentations. We will send them afterwards. And this amendment is also to find on the Legal App platform. But again, as I mentioned, I will send them as a link to all the attendees of this event. Then I would like to go to the next speaker, which is Florina Pop from the European Center of I have to put it correctly. The European Institute for Public Administration. Sorry for that. Florina is here, so she will address you from Eindhoven.
Not sure whether I need my PC or my laptop. No, I don't.
No,
need
you don't. You just.
Okay. Then I just need my notes because I prepared also with the amendments from the council. But hopefully there will be no very detailed question.
Okay, thank you.
Okay, good. Good afternoon. Thank you very much, Jos, for the invitation. And I have to say that I usually discuss about artificial intelligence and data protection in front of usually people coming from the data protection perspective. So data protection officer, data protection professionals, civil servants mainly, so public administration. And it's a great honor to be today in front of so many private professionals. So I'm looking forward to continue this discussion and to understand from your side what are the challenges, because from my side, maybe what I will have on my slides today, it's not going to be convenient for all of us here, because I'm coming from the data protection point of view, from the fundamental rights and how we should protect data. But looking forward to hear your opinion on that. So AI and data protection. Everybody here in the room, I already heard some quotes from GDPR. Everybody here in the room is very much aware, and online, sorry, I'm not using the hybrid part. It's very much aware about the interaction and intertwined nature between data and AI, simply because there cannot be AI without data. But another statement that I want to make is that whenever we have large sets of data, most certainly we'll have also large sets of personal data, so that we cannot avoid. So here is the connection between data protection and artificial intelligence. And I have to click on, yeah. So, I think too much. It has been stated that this rapid evolution that we have seen in the last years of the artificial intelligence is because it has its roots in a process called datafication. And datafication implies that we can transform any object, practice, or subject into digital data. So just think about all the data that we input every day in our Outlook, in our agenda, in our Fitbit, everything, all that data that is personal data is becoming digital data. So with that digital data, artificial intelligence has been, it was possible for the artificial intelligence, new technologies to be developed and to actually have such a tremendous use nowadays. But what I wanted to also add is that the fact that we have personal data in artificial intelligence is very clear. Who owns that data and who takes responsibility for that data, that's another story. who sets the purpose for the use of that data, again, it's another story, but really important for the subject that we discussed today. Now, the first thing when I saw the AI proposal last year in April, I asked myself, what is the interaction between this AI proposal and the general framework on data protection? So if we look into the AI proposal, we see words related to, we see concepts, not words. We see concepts like transparency, security, fairness. All these words, all these concepts, for me as a data protection specialist, are very well known because they are also included in the data protection legislation. So you can see here, I just listed for you the principle of data protection. And I asked myself, what is the relationship between these two, I call them pieces of legislation, even though it's not the best terminology. What's the relationship? Are they friends? Are they foes? Or how are we going to interpret this? Because, of course, those of you working in the data protection field as lawyers, you very much know that when we are speaking about data protection in Europe, we are not speaking just about the GDPR. We are speaking about a comprehensive data protection framework. So if we want to develop an AI system in the law enforcement for police predicting, then we will look into the law enforcement directive that deals with data protection and with the protection of data coming from that sector. But I don't want to spend too much time because this is too much introduction. I just want to say that in terms of why do I ask this question? What is the relationship between these two and how do they interact? It's just because the regulator, the European Commission at this point, it states that this legislation should complement each other. So there should be a sort of coherence between the AI proposal and the general framework on data protection. However, there are some concerns about the new AI proposal. And one of it is that it can act as a lex specialis, which lawyers know it means that a lex specialis will override the provisions of lex generalis. That's when I speak about lex generalis, I'm speaking about the framework, the data protection framework I just shared with you. So how do we, why do I say that? Because at least in terms of biometrics and collection and processing of biometrics, AI proposal does work as a lex specialis, but it actually restricts even more the use of biometrics. So that's not a problem for data protection specialists. But there is also another part that was initially proposed by the European Commission, but now there is a change, an amendment made by the Council. There is another part of the AI proposal that actually could function as a lex specialis. And this one is related to the purpose limitation principle, which means that whenever data, personal data are being collected, it is important to establish the purpose for which that data is being collected. And that personal data should be processed only for that specific purpose. But there is also some kind of flexibility in the GDPR in the sense that additional purposes can be envisaged if those purposes are not incompatible with the initial purpose. So for example, there is this example in the Netherlands, I think, when a telecom company, I don't remember now which one, has provided an authority in the Netherlands with the data that they have been collecting, so location and traffic data, because you know telecom companies have a lot of traffic and location data. In order for the authority to take some decision about the infrastructure in a certain area in the Netherlands, whether to close down some roads, whether to change the characteristic of that region. And the data that have been transferred from the telecom to the authority were not even, I think they were pseudonymized, so not even anonymous data. And in that case, the Dutch Data Protection Authority considered that this new purpose that was given to the data is not compatible with the initial purpose that the telecom operator envisaged for. So the telecom operator just has to collect the data in order to provide us with the service of our phones, but this additional purpose for the authority is not compatible. So what the AI proposal actually stated is that for certain, and I have here, for substantial public interest, so for the innovative AI system that shall be developed for safeguarding substantial public interest, and they give example, public safety, public health, also investigation or prosecution of criminal offenses, and improvement of the quality of the environment. This type of AI system could actually use personal data that have been collected for another purpose. Now, in the GDPR, the idea is that when we have to decide whether the additional purpose is compatible with the first purpose, there is a test, a compatibility test that needs to be conducted. Now, in the proposal from the European Commission, apparently this test was not taken in consideration anymore. So it was like an exemption from that compatibility test. And this is something that the European Data Protection Supervisor underlined in their opinion. But okay, not going further, this is the article that I was referring, purpose limitation and further processing of personal data. This is the one. The council proposal came and changed actually this initial proposal from the EU Commission, and I'm sharing this with you. I don't want to deep dive in so many data protection issues because I want to get also to the regulatory sandboxes, but I'm sharing this with you to see that actually we are, as you also mentioned, at the very beginning of this discussion, and we've seen, I don't know how many pages of amendments, I think 5 or 6 from the council. So this is the text that we have now is not the final text. So we will still have to dig a little bit more into how this text will look like and how we are going to create and innovate AI systems for these substantial public interest purposes. So one of the concerns for me as a data protection professional was exactly what Sophia said. Does this regulatory sandbox chapter is this a derogatory instrument in the sense that would it be possible for companies that enter into the regulatory sandboxes to derogate from the data protection regulation? Because usually, as also Sophia mentioned, these regulatory sandboxes are there for the private entities to test their new AI systems under the supervision of the competent national authorities in a deregulated space. So I asked myself the question, yes, in fintech, this was the main characteristic, to deregulate and to allow these new technologies to be tested in an environment with less regulation, or not less regulation, but at least some parts of the regulation in the fintech to be taken outside and allow these companies to better test their products. Now, I think my first answer when I asked myself whether it is a derogatory instrument was that it cannot be, because unlike in the fintech industry, data protection is a fundamental right, and it has been coined a fundamental right since 2019 in the European Charter on Fundamental Rights. So it's not only data protection right is not only included in the well-known GDPR and the other framework that I presented before, but it's actually enshrined in the EU Charter on Fundamental Rights. So how can we derogate from a fundamental right? Another reason for me to believe that this cannot be a derogatory instrument is that the gatekeepers of these regulatory sandboxes are the data protection authorities. At least this is what we've seen in practice, because today we will have the Norwegian Data Protection Authority present, but what we have seen also in the past is that the UK Data Protection Authority, ICO, has been the gatekeeper of the regulatory sandboxes. In France, it's CNIL, which is the French Data Protection Authority. So how could these authorities, how do these authorities see this instrument? And how will they actually balance the cap that they receive? They are supposed to enforce data protection, but at the same time, they are supposed in the regulatory sandboxes to deregulate. So is that even possible? Now, what we have seen in practice, and I do agree with what Sophia said, is that actually there was no derogation except for the enforcement part. So while the private companies will be in these regulatory sandboxes testing their new technologies, there will be no enforcement from the data protection authorities. And in the proposal of the council, which is new, Article 53.3, this has been clearly specified, however, under some conditions. Provided that the participants respect the sandbox plan and the terms and conditions for their participation and follow in good faith the guidance given by the authorities, no administrative enforcement action shall be taken by the authorities for the infringement of applicable union or member state legislation. Now, let's see how this proposal will work with the European Parliament and in the final part of the AI regulation. I also wanted to share a bit with you. I'm looking at the time. I'm not sure when I started, but I hope I have the time. So the Information Commissioner Office, which is the UK Data Protection Authority, had issued a lesson learned about their regulatory sandbox. So I thought, why not have a look and see what are their findings and how did they proceed? And maybe this can be used for an example for the Dutch Data Protection Authority or another authority. So they started in 2018 with this beta phase. They considered essential to have private companies in the regulatory sandbox that use personal data in an innovative way. This use is demonstrable, it has a public benefit which can be demonstrated, and also for situation when operation in the gray area of data protection law. Now, this is a bit unclear. It's not very clear what they wanted to say with that, but we will see later on. So participation in these regulatory sandboxes has had several benefits to both the Data Protection Authority and the participants. It increases awareness, compliance, and confidence in data protection standards. And also it allowed the ICO to inform, to bring future guidance. So what they actually identified, I don't know what's happening here, but they did determine that there were some parts that needed more guidance from their side, like due to the fact, and we know, due to the fact that there are so many parts involved in the development of an AI system, it's actually very difficult to grasp who is the data controller, who is the data processor, which are terminologies very much related to the accountability in the protection of personal data. So who is in the end accountable for how the data is collected, used, and processed. And this is what they identified, but this was already a subject that we knew that it's going to be difficult. The AI proposal speaks about importer, speaks about provider, user, and also developer. So different terminologies that we have seen in the data protection regulation. Now, another thing that they also mentioned is that they help the participants to conduct their data protection impact assessment. Data protection impact assessment is actually, again, a data protection terminology, but it's requested to be conducted by the entity who is going to collect and process data, especially when new technologies are being used. So for all these regulatory sandboxes, data protection impact assessment is necessary. And this is what ICO did. They did provide guidance and consultation to ensure compliance and mitigate the identified risk in this data protection impact assessment. And let me see whether I should spend a bit more time there. I think I will not read all of them because you will have then the presentation. I just want to emphasize that actually, as a conclusion, this regulatory sandbox is benefited both to the regulator and the manufacturer, but actually it proved that the regulatory sandboxes are not a derogatory instrument per se. It's more of a guidance type of mechanism. So it merely organizes access to regulatory expertise and guidance, or includes an IT infrastructure in each member state with some additional legal grounds for processing of personal data. Actually, this is also the question of the European Data Protection Supervisor. What does a regulatory sandbox do? That it's merely a guidance, or does it also provide some kind of infrastructure, IT infrastructure? I know at the beginning this was what we all thought. We thought that these regulatory sandboxes will be like these innovative hubs where the equipment will be provided and private entities will be able to use that equipment and that infrastructure in order to test their new products. But actually what it seems to be is just the first one, access to regulatory expertise, at least until now. Now in the council proposal, apparently we saw that they are thinking differently. They are also thinking that when they speak about whether this should incur costs for the private entities, they say that it shouldn't, except in particular in cases where the authorities have provided additional services for the actual development, testing and validation of the AI system, such as technical or physical environment and tools for the testing. In that situation, costs may arise with regard to the regulatory sandbox. But again, this is a proposal from the council. So, my question. Should we interpret the regulatory sandbox just as a consultative type of service rather than a complex development, testing, and validation mechanism? I think so, until now. And what I found very interesting is that last moment when I was preparing this presentation, I thought about this prior consultation, which is already included in the GDPR in Article 36. Because this prior consultation, what does it mean? It means that at the point in time when an entity that wants to, I'm trying to keep away from the data control, data processor, maybe not everybody is very much aware, but when an entity that uses and processes personal data realizes that there are some risks related to this processing, especially because they are developing new technology, and they are obliged in that case to conduct this data protection impact assessment. So to identify all the risks and all the mitigating measures that could cover these risks. And they realize at the end of this data protection impact assessment that there is no way they can cover those risks, and still the risks are high for the individuals. Then they can follow this procedure, a prior consultation. Which what does this mean? It actually means that the authority will be contacted and asked, can you help us to find a solution to the risk that we identified because we couldn't by ourselves. So is the regulatory sandbox is actually a prior consultation with, like in Article 36 of the GDPR? It sounds like that. ICO also notes that the regulatory sandbox is a service developed by them to support organizations. And other considerations that I'm not sure, I think one of them, Sophia, already mentioned it. This one is related to the strict liability and the way the European Commission decided to deal with liability. And the question is, should a strict liability regime apply to high-risk AI systems that were part of the regulatory sandbox process? Because in Article 53, you will see that the participants will remain liable for any damages that are caused in the course of their participation in the sandbox. So the regulation does not differentiate in terms of liability between AI application participating in the sandbox or not. So the liability will still apply. This is something that I also want to raise. Could these regulatory sandboxes create a false sense of safety and compliance? The fact that some private entities were in these regulatory sandboxes and tested their products under the guidance of the Data Protection Authority, would those systems be more safe? And would they be compliant? Maybe compliant, yes, but more safe? I don't have the answer. This is something that, again, I think this is the thing that Sophia already mentioned about the sandbox shopping. It's also very clear now, at least the way the text is drafted, regulatory sandboxes are not mandatory. So each member state could or not start these regulatory sandboxes. Also, there is the possibility, I'm not sure whether I think it's a new amendment again on how more authorities from different member states could together set up the regulatory sandboxes. So it's not mandatory. What if in the Netherlands we are not proceeding with regulatory sandboxes, but then in Lithuania they do, and they have the conditions of being in that regulatory sandboxes maybe it's better than in Germany. So then we decide to go to Lithuania. Just giving some examples. So this is the regulatory sandbox shopping. And I think this is my last slide. I was in a discussion with, I lied at the beginning. I said I never spoke with private, in front of private, but I was actually in a discussion with some fintech private companies about regulatory sandboxes. And they were very reluctant to participate in a regulatory sandbox because of the exposure of their trade secret and algorithms, and also very bluntly, the way they put it very bluntly was that for a company to be in the regulatory sandbox is just to teach the regulators how new technologies function. That's not enough incentive for us to be in a regulatory sandbox. So we need much more from there. But on the other hand, I'm positive about regulatory sandboxes because it can lift the quality of AI and under the supervision of the data protection regulators. And it can avoid the financial and reputational damages that we have seen in the well-known case with the childcare benefit in the Netherlands. So I think I leave you with that because I think that's a case very well known. Thank you very much. That was it from my side.
Thank you.
There is one question.
Yes.
One sec. Well, it's not really a question, maybe more so a statement. Arno believes that Article 36 is a dead letter, but may be wrong, since it sounds rather stupid to go to the authority telling we identify the risk, we cannot mitigate it. Blacklist may be an example. I'm not entirely sure what.
I don't know what blacklist is, but while in the regulatory sandboxes, if a participant is in the regulatory sandboxes, that most probably will conduct this data protection impact assessment together with the regulators. So there will be no place for hiding. And I think what the regulator does usually is try to find a solution together with the participant. But again, I'm a data protection specialist, and I do trust the data protection authorities, and I do think they are doing a hell of a job with the resources they have. So yeah, that's my perspective. That's why I said at the beginning, maybe our discussion will be a bit frictionless because I'm coming from the data protection point of view.
Good. Thanks.
Questions?
Yeah.
Yes.
You asked me to put some questions forward. So, don't you think it's strange that the proposed subjects in Article 53 of the AI regulation, those like national security, criminal justice, the GDPR is not applicable on those subjects?
Well, criminal indeed is not applicable. It's the law enforcement directive that's applicable, and the council so immediately spotted the mistake and they changed it. Because actually they also changed the legal basis in the sense that initially they wanted to use this purpose limitation principle to data that has been already collected to further use it for the AI sandboxes. But there is a legal basis in the GDPR, which is 6.1e, when it is necessary to collect and process data for public interest. And if we are speaking about special categories of data like health data or biometrics, Article 9 speaks about substantial public interest. So what the council did, spotted this, what the European Commission, what legal basis European Commission wanted to use, and decided to use this public interest and substantial public interest legal basis for the other subjects like health, environment, and research. And then they took out the criminal part, criminal and prosecution type of AI. That could use law enforcement agencies. They took it out and they said that the member states have to come with a legal basis because this national security type of subjects, they are not the competence of the EU. They are the competence of each member state. So national security has not been transferred to the European Union. So still member states have a clear authority to
Yes.
say.
Yeah. And the same with e-health and economic issues. So they can arrange that. And I think that's also what's the key, so that there will be, because it's a national authority and national sovereignty to regulate it. Nothing is harmonized. So that would be a problem. And certainly if you work on it in sandboxes, it will be a terrible mess.
Yeah, well, that's why I'm saying that I think having a regulator in the sandboxes would help to at least guide and find solutions together with the participants. But
you need a commission of combined all the regulators to have some harmonization in the outcome of this sandbox.
That's true, and something that I saw that the council changed is that they are not speaking about competent authority anymore. They are speaking about national authorities. Not sure how that impacts, but I think also other authorities can be part of the regulatory sandboxes, and there is an article specifically for that. So the data protection authorities will be there when we will process personal data in the new technologies in the regulatory sandbox, which is most of the time. But also other competent authorities, for example, the telecom authority can be involved in the regulatory sandbox and have something to add.
Yeah,
to it.
We heard that the AP is not interested in the Netherlands to take part in the sandboxes.
The Dutch Data Protection Authority.
Yeah.
Oh, it's a clear, They may change their mind.
Thank you.
Thank you.
We'll start again. We had some interesting presentations before the break. And as I mentioned, we will send you the slides of the presentations afterwards. And we will send you also a link to the amended version, the proposed amended version of the AI Act, or the proposal for the AI Act. We have two speakers to go, but two very interesting speakers. One from the Norwegian Data Protection Authority, who that's the authority also mentioned in one of the speeches before, and the authority that has experience with regulated sandboxes, AI regulated sandboxes. That will be the first presentation after the break. And then we will have someone from a Dutch supervisory authority who will give a presentation on the view of the supervisory boards in the Netherlands. But first of all, we go to Norway, to Mr. Erik Gulbrandsen, from the Norwegian Data Protection Authority. Good afternoon, Erik.
Good afternoon.
You will share the sheets from your side. Would you share them?
Okay, let me. I will share the presentation directly. So I'm doing that now. Let's. Okay, there we are. I'll just start then. Again, thank you for inviting us. And the Norwegian Data Protection Authority has worked on a project, on a sandbox project since 2020. So I'm going to do a presentation, a little background on that in this presentation. First of all, I'd like to just be a little bit philosophical about this, because why do we do this? Also, why are we interested, both as people and as a data protection authority in this? And it's a rather interesting quote from Yuval Harari, kind of puts it on edge, because when you do combine AI and advanced AI, you fairly quickly can come into a situation where you have systems that can both predict ourselves, and systems do that today. Ads, for example, are prediction services in terms of what kind of ads do we want to click on, and the likelihood for actually follow up and buying something, for example. That's the whole ad industry. And part of that is also to understand how people feel, which was a very important thing in elections. And you can also manipulate them when you know them. Okay. Okay. Sorry. So that's one of the reasons why we try to predict or try to give a signal that this is why it's important for us as an authority to understand the technology itself and hands-on understand it. So that's a background for that. We'll go through the agenda for today. We're talking a little bit about the background, why we have positioned ourselves to do this. What is the Norwegian Sandbox? How have we organized ourselves? Share some practical learnings, look at the possible futures for the Norwegian Sandbox, and also, if given time, have a little bit look at some of the exit reports from the Sandbox, which will give you an idea on what kind of problems we are addressing. First of all, the Norwegian NDPA has worked with AI as an issue for several years, a lot of years, in fact. And we have published several reports which has to do with artificial intelligence and privacy. We also has written a report on big data itself. It's getting a little old now, but it was in the heydays of big data. Now big data is more or less something that is hidden beneath AI in many ways. And at the same time, we also have what is called data protection by design and default, which are general rules for doing and developing systems, which also feel that apply to a large degree for systems that are developing using AI and machine learning technologies also. So we have worked with this for several years. And of course, the key challenge is how to regulate and secure the right to privacy. And that's our specific challenge. How do you regulate this? How can we work with the society to make sure that we are doing our job well in terms of actually trying to generate results? So a little bit about how we are communicating with the society at large. So we're trying to make this understandable, not only for the experts or the very interested people, but also the general public. What is AI and what are the issues? And of course, data is the fuel of AI, but not all data is personal data, of course. So we also need to have that understanding as a data protection authority. One of the reasons why this has become so important is, of course, the At around 2000, Google found out that you can monetize personal data. And they really changed the game there and changed from actually just looking at AI to do some interesting predictions and so on. And we found out that they can actually use this personal data to actually make enormous amounts of money. And that in many ways completely changed how personal data is being used and being harvested. So that's one of the really basic reasons for why it's been so much focus on this for the last 20 years, basically. And what is at stake, of course, is it's a human right. It's also about trust. And this trust part is important in terms of why should commercial companies or public companies spend time on privacy. And one of the key reasons are in fact trust, because we had a short questionnaire in the early 2020s. And one of the key findings there was that we now see a cool down in terms of people's use of public services, or for that matter, private services, because people are concerned about how is my data used. So a lot of the people said that they trust some services. In Norway, that would be the actually government services, and also banks are rated high, while social media companies rated in the real bottom. And that also had consequences for the social media companies, because we know that Facebook or Meta, they really wanted to introduce, for example, currency and digital money. And they haven't really been able to do that, and that has a lot to do with the lack of trust. So we see that actually being able to have a meaningful dialogue with public and governmental companies in terms of developing services that do have trust is important for the companies also. So how do we balance this huge potential benefit from AI-fueled services and the right to fundamental need for privacy? That's, of course, our key challenge. And what we have communicated the last couple of years is trying to make people understand what are the key issues here, and connected to the regulation, of course, from our point of view. And one of the key things is, of course, that you all know that AI needs a lot of data. And the unique thing with AI and machine learning is that you don't necessarily know what kind of data you need or how it is actually being used by the system. And that's a unique problem concerning AI systems and machine learning systems in particular. So that makes it difficult to balance the data minimization requirement in GDPR, because that in many ways clashes directly with what AI needs to properly work. At least that's the saying here. So what we're trying to do is find how can we balance AI and data minimization. That's one of the things we are trying to educate companies and people about. And it's also purpose limitation. Of course, you need to know why, what you are going to use data for, and you can't just reuse it for other purposes. And that's also a challenge with AI. You can look at data in many different aspects and perhaps reuse it to do other exciting stuff. So that's one of the clashes there. And of course, we have the black box problem. One thing is algorithms which are coded by hand, which you can actually understand and explain. With AI, you of course have systems that are being trained by the data itself. So explainability is also a key area. And it also maps directly onto GDPR. So that's also what we're doing, trying to tell people that there are issues here that we can map directly onto the law itself, which means that doing AI properly is not just something you do to be a good guy. It's something you do to actually follow the law. And that's a key thing here for us to communicate. And of course, algorithmic bias, which is when you actually start using these systems, you can quickly find out that they are not providing the results you perhaps expect, or it might reflect old data that might not be beneficial for new users or old users for that matter. So fair processing is important, and also directly connected to GDPR, which is excellently illustrated by a lot of documentaries. This is one of them on Netflix, which is Coded Bias, as I'm sure several of you know from before, which exemplifies the problem here. For example, that different groups of people are very differently affected by systems. It's, of course, if you train systems using students from a university, which are mainly white, then you will get systems that are good at recognizing those kinds of people. And that's illustrated very effectively in that documentary, as an example. So, is happy marriage possible? Can we do AI and also do privacy? And of course, as I mentioned initially, we do have tools today called Privacy by Design and by Default. And the Norwegian Data Protection Authority has worked a lot with this. We have actually on the EU level worked with specific guidances and trying to make them very concrete and with a lot of different tools for how to develop systems by using the principles from Article 25 in GDPR. And we're also looking at now how we can apply that to systems designed with AI and machine learning. So that's one of the tool sets we do have from before. So as a background, when the government in Norway in 2019 published a national AI strategy, and they actually mentioned the sandboxes, and they mentioned the Norwegian Data Protection Authority specifically in that strategy. And one of the reasons why they did that was, of course, that we have been very visible in many years in terms of being concerned about the problems or the issues there. So from the report, a regulatory sandbox, there it's separated. This is a generic or general description of what they think about sandboxes. And it should be an opportunity to test new technologies and business models and so on, and not necessarily just with personal data and stuff like that, but in general, it could be any type of sandboxes. They do mention legislative amendments for limited geographical area or time periods, and I just have to mention here that in Norwegian, the Norwegian Data Protection Authority do not give any exemptions for any rules or laws during our projects. So all our sandbox projects are done within the current law and the current legislation that are available. So we do not make any exemptions. That's to mention that. So I'll get back to that a little bit, which in practice has not really been a problem, and I'll get back to why it has not been a problem. But again, the national strategy mentioned the government will establish a regulatory sandbox for data protection under the remit of the Norwegian Data Protection Authority. So we were given a direct assignment in that strategy. And of course, the reasons is that enterprises can get a better understanding of the regulatory requirements. That's one of the key areas, trying to educate the possible developers of systems and also buyers, of course. But also because authorities, including the Norwegian Data Protection Authority, should get a better understanding of what issues are there out there. What kind of problems do the different companies and public organizations need to solve? It's not given that we can intuitively know and understand what kind of problems which are out there. So it's, very important for us to understand the different problems, and I'll also get back to that. It's also because this kind of work can identify sectors with specific needs standards. So we also see some, so we'll be starting to see some possible sectors there that might need special follow-ups there. So it's already started to generate follow-ups from that. And of course, we are trying to be positive. Also, Datatilsynet, or the Norwegian Data Protection Authority, has in many ways not been overly optimistic, but we are positive towards working with companies in terms of AI. We are trying to be in many ways project a positive and optimistic view on the technology itself, of course, within the bounds and rules. So that's the framework for how we started up and why we could start up. So basically, we started up early 2020, right after just a couple of months after that report, or that national AI strategy. We decided to be a consultative service. We are not doing any kind of accreditation or validation of systems as such. We are working in dialogue with the companies, and we comment on problems and issues and suggest solutions and so on, but we do not in any way validate or acknowledge or prove systems as such. We don't have that authority within the GDPR anyway. And as I mentioned, there are no formal exemptions given in the project period, which again has not been a practical problem for us. And as I mentioned also, we wanted to protect a possible optimistic interest in AI. So I think people feel that the Norwegian Data Protection Authority are genuinely interested in trying to find good solutions. We're not going into that in a sandbox project trying to find faults or trying to be overly negative. And at the same time, of course, we do it within the bounds of the GDPR regulation. We were given a 3-year period from 2020 to 2022, so we are now currently in the last test period, and what will happen after that, I will get back to. In the first round, we got about 25 applications from different companies, and we selected 4 projects. And basically, we had this mix of applicants. A lot of health applicants and health and welfare, and also some from finance. But as you can see, health is a very the Norwegian health system is working heavily with AI and really want to find out if they can do interesting stuff with AI. And concerning the different issues raised, it was transparency, also the need for transparency, openness in terms of how they do process data with machine learning. Data minimization was mentioned, and also fairness. So that was some of the key things they wanted to discuss with us, which were subjects in the reports. And also give you some very specific and concrete examples of this at the end of the presentation. We had some formal criteria for what kind of applications we accepted. Of course, you have to use AI, and we have in practice been a little more restrictive because we also, in reality, we have said not only AI but machine learning as such. In practice, this doesn't mean that we could include other types of AI technologies other than machine learning, but in practice so far it has been machine learning. And the project has to have benefits to the society and for individuals. So it couldn't just solve a problem for the applicant itself. It has to actually solve problems that others can use. And then one interesting thing is that there has been a great willingness to share findings and share knowledge from these projects. The different projects participants are very willing to share. So that's a very positive thing, which was some of the things we are a little bit worried about when we started. Will be a lot of no disclosure agreements and so on, but that has not been an issue at all. To some degree, because a lot of the projects are in early phases. And the project must benefit from actually participating in the sandbox. It couldn't just be that you participate to just show off or try to get some press coverage. So that's also a key criteria. And of course, you have to be associated with the Norwegian NDPA. And as I mentioned, it has to be relevant to others. And I have to be willing to share information. So that was the basic formal criteria. And when we explain the regulatory sandbox to the different people that consider putting in an application, these are the key benefits, which is to a large degree echoed from the national AI strategy. So for the industry itself or the governmental companies, it's getting better understanding of legal requirements, and also trying to describe and find out and lift their awareness of what does it mean to actually can you do it and how do you do it. It's not always the data protection authority that had the answer to that, but we often find ourselves starting a dialogue and which the participants actually come up with very good answers, but they needed the questions to get to the answers. So that's been a very useful two-way dialogue. And for the DPA itself, it has been a very important tool for us to build internal competence, and it has also been important for us to actually have the whole organization take part of this. So we are a small team which is working in the sandbox directly, but we are including resources from the entire organization, also as project leaders and workers in the sandbox projects. So we actually have 3 people. I'm one of them that work in the sandbox itself, but we have other 20 and 30 people that has been as a short-term part of the different projects, which means that you have 20, 30 people in the Norwegian Data Protection Authority today, which actually has some pretty good understanding concerning AI issues. And that's pretty impressive in an organization which counts about 70 people. So that's been a very, very good thing for us. And of course, the last thing is that for the public, is that we want to actually help the society to how can you build a solution that you actually can trust. We want to see positive and good projects. So the first 4 projects was NAV, which is a Norwegian welfare organization. I'll get back to them. EdTech, as education technology. Age Labs, which was health and prediction of age-related sicknesses, and Secure Practice, which was actually trying to profile employees in a company to find out whether or not they are good cyber citizens, which is, of course, could be fairly controversial. So that's also an important point here, that we didn't only choose projects that we felt were good or easy to work with. We actually chose projects which we knew could be controversial. But we, as a measure of success, we actually said that telling a participant that we do not think you can do this in a good way, we don't think you can do this in a way that supports GDPR, is also a success for us and probably also for the participants, which on an early phase can find out, okay, we're thinking wrong. And one example was Secure Practice, which actually had a way of thinking about doing this, which wouldn't have been a very good way of doing it. They would probably clinch with us at a later point. But they changed the business model and they changed some things about the technology. And they do now have a way of implementing profiling, which we do think could be to be actually fairly good in terms of respecting the employees in the company, not giving the employer access to raw data and so on and such. So a big part of the project has also been publicizing and leveraging the output. So we have project plans and exit reports, which will show you at the last as the last slides. And we also spent a lot of time communicating here. We actually have hired a journalist as part of the core team. We are making podcasts, blog posts, articles. We do have a lot of newsletter publishing in different newspapers and so on. And we do also offer trainings and workshops and stuff like that. So that has been a big part of the sandbox, and an important part of the sandbox. So we are fairly transparent. It's easy to understand for external parties what we do, what we're trying to acknowledge or find out, and what kind of projects we are working on, what type of problems we want to solve, and the result of that. So that's been a very important part, and we've gotten a lot of very good feedback on that. Our openness towards how we do that. So it's not a closed box and you get some report in there, and it's fairly open. And that's also been important for us in the exit reports, that we not only share end conclusion, we also tell people about the process. And that's also one of the key feedbacks we've gotten when we do publish guidances and so on, that people think guidances are interesting and good and could be useful, but they often want use cases. And they also want to understand why do a guidance recommend that or this? What were the options? What was the thought process to get there? So that's also been an important part of this project. So very quickly, what have we learned? There's a lot of interest, a lot of positive interest. So that's good, both from public, governmental, and private companies. It's good applicants in general. But some of them, a lot of them do need actually fairly basic guidance. So that's something that will affect our priorities in terms of how to communicate with the society as a whole. We do understand now that there are need for a lot of basic guidance, not necessarily by the NDPA, but there's a lot of possibilities there. Most of the projects has been in the early phases. So a lot of the possible issues with bringing a project to us and finding out that you cannot do that, or that's not a good idea to do that, hasn't really been a problem, because they have been in such an early phase that we have identified that, and actually in some cases fairly substantially changed how they design the project or the service for later phases. And as I mentioned, there's great willingness to share ideas and findings. That's been positive. And shedding light on gray zones through use cases, as I mentioned, has been very useful for all parties. It's been important to build internal competence in NDPA. And in general, we are often used to having meetings and telling people what to do or what they have done wrong from our point of view. And having the ability to have good two-way dialogues has been good for everyone, including the NDPA. So, as I mentioned, openness and communication plan is key, and has been one of the successes of this project, actually being very visible, very open in terms of how we work. And that also scales the effect of the sandbox, which was one of the key criteria when we started, that we wanted to make sure that what we did here scaled. So for the last round, for this test period, that was March 25th. And one of the other outputs from the sandbox is a guidance on transparency, which are in the making, which the sandbox itself is not making, but we have the organization has picked up on the need for that and are creating a guidance on transparency. And we also started the process to actually try to help some governmental companies adapt the legislation. I'll mention that in specifically. I know I'm a little bit over time. I will be finished in a couple of minutes, hopefully. Let's go. Yes, okay. And of course, we do have the AI Act, and that's a little bit part of possible futures for us. You all know this act, so I'm not going to go into that, but of course sandboxes is a part of the text, the text there. And it's also talk about ban on acceptable risks in terms of using AI, so that regulation can be very important, which brings us the possible futures of the Norwegian sandbox. Methods developed from the sandbox might be implemented in the organization itself, so that's one effect. We're also looking at establishing a permanent sandbox, which depends on the external financing. The sandbox was financed by the Norwegian government. So in a couple of months now, we will get feedback on whether or not they want to do this permanently. So that's exciting times for us for the next half year, I think. We'll wonder about that. And of course, at some point, there will probably be an AI Act, and sandboxes is, of course, currently part of that, of the innovation perspective there, but it's also interesting to find out who should be the regulating authority in Norway for that. And it's not given, but one option is, of course, the NDPA. And given the competency we are developing now, of course, the AI Act doesn't only concern personal data, so that could be an interesting thing we need to find out about. So far, 3 reports, approximately 15 to 20 pages each. 4 will be published additionally, and we'll have 3 to 4 reports this year. So there will be between 10 and 11 reports in the entire project period, plus a lot of blogs and podcasts and articles and so on, plus the transparency guide and perhaps an additional guide, and also work with the organization for legislation. And very quickly there, one of the projects was with the Norwegian Labour and Welfare Administration, where the hypothesis was that there were too many unnecessary meetings, and they wanted to actually predict whether or not they needed to actually have meetings with the people on sick leave. Because some of the people on sick leave actually doesn't really need that guidance. It's a second meeting we're talking about, and they wanted to more accurately predict who they could just skip that meeting for. So that's what's the hypothesis. So it's a prediction of development of sick leave on an individual level. And as a part of that, there has been started, as I mentioned, a legislative process, because we did find out that in order to actually use AI for that they did have legal grounds for doing, but they had the issues in terms of training the system. So that's one of the things we found out. And we also have this report both as a PDF in English and as a web page in English. So you'll get the presentation and can perhaps use the links there if you want to go in and read. The issues we discussed there was lawfulness, fairness, and transparency. That was the key issues for that report. Secure Practice, the cyber security project. They wanted to develop a service that profiles employees, which was, again, a little bit controversial. And the question was, can you profile employees while reducing or removing the drawbacks? And it wasn't given that we would conclude that was possible. But in many ways, we did conclude that done in a specific way, it could be possible to do this. And the issues we discussed here was processing responsibility, legality of doing this, and of course the data subject's rights and freedoms as an employee, and transparency in how this is done. So that was the key issues there. And the last one, this is education technology, activity data for assessment and adaptation. Also, actually, how can you use AI to assess education by students, which again is controversial, and in many ways trying to find out, are there ways to do this? Can AI be used in schools to help learning processes? And again, what we looked at there was legal basis, impact on privacy for students, and again, transparency. So these reports are available for download, and you can look at them in English. So that's what you have there. And that was my presentation. So,
Eirik, I see that there's one question in the chat. If you can answer it quickly, then we can then move on.
yes. Yes, the question about if we work with other supervisor, and yes, we did, both for health and finance, in fact.
Great, thank you. Then we will now continue.
Thank you, Eric, for your presentation. As I mentioned before, we will send the slides to the participants, and the slides will provide will have the link to the website of the Norwegian Data Protection Authority. I'm very interested in looking at the documents there, especially whether they will help us with things like a sandbox plan, an exit plan, the agreement between participants to a sandbox. So I'm really going to visit the website and look for these documents. So again, thank you for your presentation and for answering the questions.
You're welcome.
Then we move on to our final speaker, Huub Jansen, from the Dutch Agentschap Telecom. After all the presentations, I'm very looking forward to having him on the floor and hearing the view from perhaps a struggle from the supervisory authority perspective. So the floor is yours.
Yes, thank you very much, Jos. And thank you also for inviting me, give me the opportunity. I do think it's very good that we have this meeting now, even though it's still early stage for the AI Act. But I think it's a very good moment to start this discussion, and it will probably continue for the next few years. So I hope under the umbrella of the NL AI Coalition, we can have more of these kind of discussions in the next few years. And it's also very interesting because you bring in a lot of different perspectives on the same topic. And I will try to do it as well to take you into a very different world and a very different perspective on the questions here. And I'll probably go a bit broader than just sandboxes. I'll try to put it in a broader perspective so you understand also how a competent authority looks at also the regulatory sandboxes. To start with the broadest idea, the idea is we want a strong European economy. We want a certain kind of digital autonomy in Europe, also in the area of AI, which means that we want to stimulate the Dutch and the European companies to develop AI and to make a profit out of it. And at the same time, avoid too many risks for citizens, but also for society. So the AI Act is mainly focused on limiting the and at the same time, the regulatory sandboxes to make sure innovation is sufficiently possible. So that's the framework of how we look at the regulatory sandboxes. So what I'm going to do, I give you first a small introduction, then I'll make some remarks concerning the AI Act, which is a little bit different than the approach we've seen so far this afternoon. Take you along in the world of competent authorities and supervision on AI and how does that work. And in the end, I'll give you a use case on already supervising AI based on current legislation. How do competent authorities do that? First of all, about Radio Communication Agency, not everybody knows it, but we are a kind of digital infrastructure authority. Everything from connections, physical, through the air, making sure everything is reliable, secure, safe. So very much safety oriented and very much technical oriented. So also certifications on electronic communication to make sure everything vital works. You also asked me to say something from the perspective of the competent authorities, but I'm doing it from 3 different roles that I have. First of all, I'm responsible for AI within the Radio Communication Agency, but I'm also the chair from the Dutch working group of competent authorities. At the moment, there are already 21 competent authorities, as well as the 3 ministries in my working group, which we use to share information, share knowledge, try to work together, discuss use cases in order to try to get some kind of comprehensive approach from the different competent authorities. It's always a struggle, but it's very good that we have this already for about almost 2 years now. So we started this even before there was an AI Act. So it's not about the implementation and competent authorities on AI, but also on current legislation. And the third role I have, I'm the chair of the European Working Group of Competent Authorities on AI. There are also the European Commission and ENISA involved in the working group. So what I'm going to tell you is a bit combination of all those 3 roles that I have. Concerning the AI Act, we already mentioned it, it's not yet agreed. So the text is still being discussed, but certain areas of the agreement will probably not change very much. But this part of the regulatory sandbox is still very much in discussion, which means that I'm not going too much into detail on this part because it can still change quite substantially. Too bad or great, because one of the reasons we have this meeting here today is because the Ministry of Economic Affairs, who is the coordinating ministry for this regulation in the Netherlands, asked the entrepreneurs, VNO-NCW, what do you think? How do you want to do it? Do you have any input? And they asked companies, and that's why you organized it. So it gives also the opportunity for everybody here to, if they have certain ideas or demands or suggestions, give it to the organizers here so they can transfer it to the Ministry of Economic Affairs so they can take that into account. So is it, yeah, so it's good and it's not good, but that's the way it is. The core of the regulation is product legislation, especially the high risk part. Very similar to the medical device regulation, based on the new legislative framework. So in that respect, it's a very different legislation than, for example, the GDPR. And a lot of different ways, but also a different way of how to supervise it as a competent authority. A lot of products need to comply to regulation, AI toepassingen aangeven. You just mentioned it before, and I forgot. So AI applications need to comply with the regulation, but how do you show that you comply? And that's mainly based on standards. So it's crucial that there are a lot of standards so you're able to show compliance with the regulation. And there's a role for the European standardization organizations, mainly ETSI, CENELEC. So they get a mandate, a request from the European Commission in order to make the standards that can be used for conformity assessment. And from our agency, the communication agency, 4 people are just busy within NORE, NEN, ETSI, CENELEC to help establishing these standards. And last but not least, AI and cyber. If you look at the main risks of AI, one is data, personal data, and that's because of the fundamental rights, it's because of democracy, it's because of manipulation, so that's one major risk. The other major risk is cybersecurity, And so that's mainly focused on safety. And you look at the regulation, it's very much risk-oriented and about safety. So safety is a very important aspect as well, which we haven't hardly addressed here at the moment. Especially on this area in the European working group, we're working a lot together with ENISA. They already published several reports on cyber and AI. And well, they have 4 new projects this year, together with my working group, to be published this year as well. So that's going to be a major topic. Go a little bit into detail. It's AI needs to be protected, the data, the algorithm, in order to make sure it works the way it works. It's AI to protect yourself in cybersecurity, and it's AI that is used to compromise you. So AI and cyber works in different ways, and depending on how you look at it, it has a certain effect. So don't forget the aspect, it's not just personal data, it's certainly cybersecurity. The second reason why I want to stress that, because we do think that the major innovations in the next few years will be of a combination of the introduction of a lot of IoT devices, 5G, and cloud computing and edge computing, together with AI, will have a major transforming effect of society. And most of all those data are not personal data. And I expect that most of the experiments in regulatory sandboxes might be in this area. So I try to stay a bit away from all the personal data discussion. In the Netherlands, we have a working group of competent authorities, and they are all working together, trying to cooperate. But every competent authority has to act based on their legal legislation that you use. For example, we work based as radio communication agency. We supervise on the telecom regulation, on the EIDAS regulation, on the NIS directive. So a lot of legal grounds, and that determines how you look at a certain company or a certain use. So if we look, for example, at the telecom agency, it's not our task to look at data protection. We look at resilience, at stability, at continuity. So every competent authority looks from a different side, and everybody has a different role and different powers. For certain areas, for example, radio devices, we have a product legislation role. So we check electronic devices before they are allowed to be put on the market. Another role concerning telecom companies, you have permanent oversight, permanent supervision. So every year you go there and you check a lot of things. If you look at, for example, the GDPR, it's mainly focused, the data protection officers usually focus after it's been implemented on how the effect is based on signals of information. So there are a lot of different ways that competent authorities work, and that gives some friction on how can you cooperate. So everybody wants to cooperate, but you always have to look from which perspective is somebody looking. And hence there are some different visions on how cooperative or how strict a competent authority is. That's fine, because we have a working group where we can discuss these things. And we don't always agree, but that's a basic ground for discussion. It hasn't been decided which role on the AI Act the different competent authorities will have. Which competent authorities will be appointed for the AI, which can be multiple. There's a role for the National Supervisory Authority. There might be a competent authority for the regulatory sandboxes, or multiple. We don't know. But at the moment, we know that they all lack resources. Well, we try to cooperate and work together in order to help each other with the limited resources. And even though we try to cooperate, by definition, they're all independent. So you can't force cooperation, but you need to stimulate for it. Well, that's my main role as a chair to facilitate that. When it comes to the AI Act and certainly also the regulatory sandboxes, I do think it's very crucial that we have the dialogue like we have today, and we have use cases. This will also help the competent authorities to discuss not on theory, but on a specific use case. So if you have specific use cases you want to send them to the organization, and we'll receive them, which could help us to better organize our work as a competent authority. Last but not least, I want to go into a specific use case. So a use case from the Radio Communication Agency concerning the eIDAS regulation. The eIDAS regulation, one part is trust services, which is, for example, in this case, qualified electronic signature that can be given. We do oversight on that, and we need to make sure they comply to regulation. One of the requirements is that if you give a qualified electronic signature to a certain person, you need to make sure it's that person who gets it. And that means until now that you need face-to-face control, face-to-face check. Is somebody really the person who they say they are? Partly due to COVID, one of the companies said we would like to use an AI for that. So they don't need to get to the office, we can do it remotely. And we need to approve that. So this is already supervising AI based on, you need a legal argument. It's not a lot of competent authorities are trying or testing, but this is, you need to make a stand as a competent authority. So based on the eIDAS regulation for the trust services, and you want to stimulate innovation, and at the same time, you need to make sure it's compliant. How do they want to use the AI? They want to actually use two AIs. One is the liveliness detection. If you look at somebody's camera, is that really a live person? Is it not fake? Is it not manipulated or whatever? And the second one is the face comparison. How do you really know that somebody is the person? Because you get you read an electronic identity from a passport, and how do you make sure it's the same person? I can't go into all the details on how we exactly did it, so I'm just taking through a few highlights. What we did is you really need, as a competent authority, to have a multidisciplinary team. So what we needed, you needed people who knew something about the domain, about specific regulation. You need somebody who knows applications. You need somebody who knows AI technology, algorithms, data science, and statistics. I was surprised how crucial statistics is. It's all about interpretation of the outcome of data and the statistic analysis. So statistics was, in my view, much more important. I thought it's mainly data science and algorithms, but there's a lot of statistic discussion. Software development, system integration, and IT auditing. So you need a whole group of people all looking at the same AI in order to make sure you can say it's whether or not it's compliant to legislation. Oh, I think I missed one. I already skipped one slide. Yeah. And it's not just the AI. AI is only a very small item, so you always need to look at whole picture. Context is key. Where is it located? What is the role of the AI? So it's the AI check, it's the application around the AI, it's the part of the process where it's needed, and the total process, the service it delivers, and in the end, the whole organization. Who is responsible? How do you maintain compliance, etc. So it's a whole framework you need to look at if you just want to say, yes, it's acceptable, it's compliant to legislation. Just to make sure that you don't think if you want to work with an AI that a competent authority just looks at the AI. It's a service you offer, and they need to look at every aspect that's relevant for the service. So it's service oriented and not just AI. Questions, but my questions to you, maybe also some questions for you to me, but in this case from me to you. Why wait? You can already start. And one of the reasons I put this here is because expect that the main reason why there are regulatory sandboxes is because usually it's focused on the regulation itself. So if you want to experiment and you don't want to comply to every aspect of the AI regulation, there is some room for experimentation. It's not meant, or will hardly be meant, to use to put other regulations out of order. If you think you can bypass the GDPR by regulatory sandboxes, I don't expect you'll have a lot of luck. But if you look at, for example, complying to an high-risk AI, you need to comply to a lot of things like documentations, ISO certifications, or whatever. If you don't want to do it as an SME, or if you don't want to do it, if you just want to try an innovation, then you can probably ask for an exemption on, for example, all the documentation needed, and first try before you comply to all the things you need to do. So I do think that will be the main issue of the regulatory sandboxes, but still there is no AI Act in place, so you can do anything which is not allowed. So try to do it before there is the AI Act, because as soon as there is, then you have a problem, but then we have maybe a little bit of regulatory sandboxes. I don't know how, but if you think we can help you, because yeah, somebody needs to laugh here. In the end, we all want Europe to be sufficiently developed on AI, a strong economy, strong economic companies on AI, because that's what we need. So in the end, we're all for the same goal here. So if you have specific questions, remarks, desires, relating to this regulation, please inform the organizers. Thank you very much.
Do we have questions?
Yes, actually one from Evert. He asked, do you take context in a purely technical meaning, or is the human / professional user context included?
It depends on how you look at it from a competent authority. So, for example, in this use case, we need to make sure they comply to certain regulations, the EIDAS regulation. So we ask, how do you comply with the EIDAS regulation? If a human is part of the implementation of the regulation, then yes, it's included. Sometimes it could be people, but mainly it's a role. Is there a specific role? Is there somebody responsible? So yes.
Okay. That is the one and only question, or at least from the chat, maybe in the audience. There's two actually.
Okay.
You want me to?
Yeah, that makes it a bit easier for the rest to.
Yeah, actually, I have a supervision question, because if I'm correct, the Council for the Judiciary is going to supervise the AI tools, the use of AI tools by courts, for example. But what if the Council itself might want to experiment or use AI tools.
Yeah.
Who's going to supervise that? Do you have any idea or suggestions?
It's mainly so one is for the public service. It's the Auditdienstrijk and the Algemene Rekenkamer. They are the one who are going to supervise it.
For the council.
Yeah, and they have already published last year a framework for it. So on the website of the Algemene Rekenkamer, you can find the framework they have for this kind of uses.
Okay.
And there's also under the Dutch AI Coalition a special working group of public officers, public authorities that use AI to learn from each other.
Okay, thanks.
And another question.
I had a question concerning supervisory authorities. If I understand well, you represent all 22 supervisory authorities in the Netherlands?
Well, not officially represent, but they are part of my working group, yes.
By the way, so how do you agree on whatever? Because I think that's quite impossible.
Well, fortunately, we don't have to agree.
Okay.
So what I said, by definition, they're independent. But what you want is to converge in understanding. But in this phase, it's mainly sharing information, discussing use cases, being able to find each other when there is a specific use case which is addressing multiple competent authorities, so you can work on a specific case. And for example, between the Dutch Telecom Agency and the Data Protection Agency, AP, we're working on a protocol to work together and to address certain cases at the same time together. So we're trying to work more together when there are specific cases which relate to both of us. So you use it to work together, but we're not going to, it's not a decision-making working group.
You correctly said we are trying to work together.
Yeah.
That's representing the issue quite well, because you have to bring it to Europe as well. So it's a difficult job, I suppose.
Yeah, but it's mainly, in this case, when it comes to regulation, it's the Ministry of Economic Affairs that has to put all the...
You gave an escape, you said the regulation is not applicable yet.
Yeah.
But a lot of other regulations are applicable.
Yeah, absolutely, yes.
Okay, good luck.
Yeah, thank you. Thank you very much.
Thank you. Thank you. The last presentation of this afternoon. Thank you all, the ones here in Eindhoven at the AI Innovation Center. The participants online, thank you also for participating in this event. As I mentioned already a few times, we will send you the slides from the presentations of this afternoon. We will send you a link to the documentation regarding the AI Regulatory Sandbox, also the proposed amendments from the European Council. And as mentioned a few times, this is not the last event or the last what we will organize on this subject. We would like to follow the subject of AI Regulatory Sandboxes, to give input to the Dutch government on how to organize what kind of rules we need on this subject in the AI Act, and also what we need nationally. So all the input from you is very welcome, and also the invitation from Huub. Why wait? Why wait for the AI Act to organize AI regulated sandboxes? That's what we would like to organize. And as Huub mentioned, there are some subjects, the subjects he mentioned, that are that might be perfect subjects for organizing an AI regulated sandbox, together with the competent authority, the authority Huub is working for. But perhaps there are other examples, other issues that are suitable for a pilot, for a AI Regulatory Sandbox. So if you do have suggestions for a pilot, for a subject for an AI Regulatory Sandbox, please let me know, and I will contact you and try, and we will see whether that is a good subject. The Dutch AI Coalition is interested in supporting a pilot for an AI Regulatory Sandbox. The Dutch Society for AI and Robot Law is interested. The last one you can become a member of. So if you have suggestions for us, please don't hesitate to let me know. And again, I will send you some documentations after this event. And again, thank you for participating in this event. Thank you. And for the ones here in Eindhoven, we have drinks and we get some snacks. Thank you for participating, and see you next time.